And we're back live.
All right, we're back. This is Senate Health and Welfare, and we are looking at draft 4.1 of H 121, which is the Consumer Privacy Bill. Just want to share, before we begin, we did have a bill up on our wall as 273, which deals with consumer privacy. It's 273, 173. That deals with consumer privacy that I brought back from Washington DC when I met with a group of people from across the country. It's based on Washington State. My understanding is this is based on a different set of states. So they integrated what was included in S 173 in this bill. So we'll go through and see what relates to healthcare. And John, thank you for being here.
Sure.
Do you know everyone around the table?
I do not.
Okay, so quick introduction to Senator Blewett.
Hello, Ian Rockport, Burlington, Essex, Winooski, Colchester.
I live in Winooski, so there
There you go. You're my
Used to be.
constituent.
Good morning, Dave Weeks, Rutland Council.
Ginny Lyons, Chittenden Southeast. Just all the benefits.
Terry Williams, Rutland County.
And you know,
Green Party, absent.
John Gray, so legislative council. I haven't had the opportunity to be in here yet. I will quickly screen share so my face is not appearing on the screen. Before we jump in, and I may not really need to go so much to the text at this point, just because I do want to get high level and we could accidentally get super into the weeds on this. Let me give just an overview of what the bill does as a whole, and then I'll try to call out particular things of relevance to this committee.
Which version are you voting?
4.1.
4.1, okay.
And if it is, I hesitate to hand these out while I am explaining something, because I know people start reading as soon as you hand them the document. But I will just hand you, you guys can pass this around the table. This describes everything I'm about to say, which is just a high level overview. So you don't have to read it right now, but if you need to look at this later, it might be helpful.
good.
So who does this act apply to? So just generally, this is meant to be a comprehensive data privacy regime. So it addresses a whole host of concerns. It addresses both data security, that's maintenance of practices that secure data, and also privacy concerns. So
Do you have another one of these?
I
want to give one to Kiki. So.
yes, I have one.
Okay.
Yes.
Thank you.
So broadly, this is addresses a large scope of data security and privacy practices. This is part of a nationwide effort. States have been trying to pass these kinds of bills. Washington was actually the originator of some of the large data privacy principles in the US. Their bill did not pass, and so other states kind of took on the mantle of comprehensive data privacy regimes. Connecticut is the state that we have most looked to for the provisions that are here. So just recognize that this is part of a
Representative or Senator Blumenthal? He was good at that.
and I know that those folks have been open to, testifying and talking about pieces. And the health specific pieces that are in this bill came from Connecticut, just to call that out. But what does this bill do largely? So it applies to only a certain set of entities, folks who either conduct business in Vermont or produce products or services targeted to Vermonters, and that meet certain thresholds. So during the preceding calendar year, they either control or process. So we'll come to those concepts. Personal data of at least 25,000 Vermonters, or they derived at least 50% of their revenue from the sale of personal data. So this bill applies to folks who are targeting Vermonters and meet certain thresholds, either of revenue from sales of data or dealings with personal data that meet 25,000 Vermonters.
And as passed by the House, that was a much lower number, wasn't it?
It was, yes, so what the House did is 6,250 Vermonters was the threshold. It was based on a percentage, so 1% of Vermont population was the idea. Other states that have adopted comprehensive data privacy regimes have similar. If you look at theirs from a percentage standpoint, their thresholds are around the 1 to 2%, and some folks dipping below that. So the initial House passed version had a much lower threshold that was supposed to align with 1% for the first piece. And then the second piece for revenue sales was 0.5%. plus derived at least 20% of gross revenue.
So what I'm gonna suggest is that we keep our eyes on the prize, which is healthcare. And a lot of the work that Economic Development Committee has done will be reported, but there are differences between what the House sent over and what's here. So I know we all wanna dive into this, I get that. So, but question of clarification, and then we're gonna keep moving forward. Go ahead, Senator Reeves.
No,
No, okay. I know, we could, as John said, we can get into the weeds pretty quick.
We will lose all of our time if, yeah.
Yeah.
So that's broadly who the act applies to, but there are instances where we remove those thresholds and we just say that anyone who is a business, conducting business in Vermont or producing private services targeted to Vermonters, it applies to those folks irrespective of the thresholds. And that's your pieces that are related to minor protections and relevant to you guys, consumer health data, which is a specific section 2426 that we will come to. So just to call out that there are no thresholds in place for those particular protections under the act. There are a lot of exemptions that are set out in section 2417. It provides both data level exemptions, meaning these are exemptions that are tied to the kind of data being processed, but not the entity processing them. And we also have in that exemption section, entity level exemptions, that is an entity operating in a particular way. If they're a financial institution or something of that sort, they are exempted just by virtue of being that kind of institution from the act. The way that health exemptions are,
Okay.
yes.
No, I'm not gonna ask it. No, keep.
So
You don't have
strong,
to raise
so
your
strong.
I know, but I'm.
And we can, so I think it is nice if we get through this page and then come back. Yep. I will say the way that health exemptions, the HIPAA related pieces are addressed in the exemption section are through data level exemptions rather than entity level exemptions. I'm guessing, I haven't seen what you folks are receiving from folks on this bill, but I'm expecting that people will be asking for entity level exemptions rather than data, which is what we currently have. So
You're so prescient.
it's a nice predictable world. So what does the bill do? It grants Vermonters a set of rights with respect to their personal data. And personal data is just information that can be linked to a person, and technically it's also if it can be linked to a device in their household, and that's meant to get at things like if you have cloud services that everyone's using Alexa or something in the house, that if you could track through that, we would want to get at personal data that way. So the bill grants Vermonters rights with respect to their personal data. Those rights are confirmation and access. So businesses that are processing their data, they can confirm what kind of information is being held on them, and they're able to access that information as well. They are granted the right to notice of third parties to which that personal data has been transferred. So businesses may be selling that data or transferring to others. Consumers would have the right under this bill to know who those third parties are. So in the event that they need to contact those or ask for that third party to delete their data, whatever it might be, they would have that information. Vermonters would have the right to correct their data. It's possible you have bad consumer reports on you, and that may be denying you certain pieces. So if you can access that information and correct it, then you can prevent accidental harms on the basis of information that may be fairly maintained. Vermonters also have the right to delete information. They can request the deletion of their personal data. The right to data portability. This is kind of tied into that access piece. It's just to say that they could receive that information from a consumer, a controller or a business in a way that would allow them to send it to somebody else. The way that I think about this concept is, let's say you apply to an apartment complex and you have to provide certain information. It costs you $20 to provide the data on yourself. You don't have to pay that fee every time you go to some other place. So if you could access that information that you're providing to them, and then you could hand it over anytime that you apply to another something to that effect. And lastly, and very importantly, Vermonters have the right to opt out of certain kinds of heightened risk situations. So targeted advertising, the sale of personal data, and profiling to make significant decisions. And what profiling is when people are making automated decisions on the basis of information that they have about you, and it's going to have a significant impact on your life. And there are particular things we call out. It's actually a list of items that are considered significant. So automated decisions that might deny you housing, a job, insurance, something like that.
You can tell this came from economic development. You've got all the housing.
So could there be a provision in this bill that required anybody who has your data that every year on an annual anniversary of that date, that they have to come back to the consumer and say, we got your data, we want your permission to continue to use it? Because what I'm seeing, and I actually, a lot of people, like organizations are putting warnings on there that, you know, what we can do with your data. But it's kind of like when you apply for something online and give them your credit card number, it says this will be automatically updated on 1 year from now. I always check the box that says, no,
Right.
you need to come back to me. But a lot of people don't know that. They're not reading the whole thing.
So there are, I think, two things that are salient to your point. One is a general principle about the bill, and another relates to how sensitive data, which includes financial information, is handled. So the principle that's relevant is you could have a data privacy bill that says businesses can't do anything. In fact, they have to secure your consent to do anything with your data. That is not what this bill does. This contemplates largely business as usual and provides for opting out of. So the presumption is that businesses continue to operate the way in which they do. Consumers are provided notice of the kinds of things that it's going to be done with their data. And there are limitations to how businesses can handle that data, but largely they can continue to do their business. There are, however, and this is relevant to your point, certain instances in the bill, and this is that last right about opting out, that go away from the general opt-in regime of the bill, which is to say, if sensitive data, including financial information, is being processed, businesses have to secure consumer consent for those things. So it's unlike general operation. In those instances, you actually do have to have someone affirmatively say, yes, you can use my financial information for those purposes.
Because a lot of times the company that I purchase something from online, you come back to me and say, you know, not only do we have your credit card number, we have your personal data. And I'll go, gee, I don't remember doing that.
Yeah.
So, you know, things change over a year.
So we're now getting back into the weeds.
Sorry.
You have one question.
Yes.
Is the opt-out at what level? Broker level, ISP, or what?
This is for anyone who is controllers who are subject to the Vermont Data Privacy Act. So those folks who met those thresholds that we just talked about. So someone conducting.
You have to link with every single one of those in order to opt out of their access to your data.
The rights.
Sorry, I'm trying to figure out what the individual has to do.
Oh, what they have to do.
Out, yes.
Oh, okay. It's a simple mechanism. So
That's all.
yeah. Sorry, I think I was misunderstanding the
Yeah.
question. Controllers, the folks who are subject to this act, the businesses who are subject to the act, are required to provide a mechanism, a readily accessible mechanism that will also be described in a readily accessible privacy notice that allows you to opt out. It's meant to be a simple process. We have pieces in place to say you can't make it harder than the pieces that advantage them, right? Like they can't set up means of securing your data and then make it really complicated for you to opt out. It's got to be just as simple as it is for them to secure that data. And there will be clear disclosures both in the privacy notice that that mechanism is available to folks, and then the mechanism has to be set up. And there's also meant to be, at some point in the future, although it's not happening yet, education and outreach to consumers to make them aware of what rights they would be afforded under this, including their ability to opt out.
Okay. Okay, let's go because we need to get to the help.
Yep. So
My fault.
on that point, that we do have pieces that are related to protections of minors. I won't delve too much into detail on this, but if a business is offering online product services or features to someone that they know is a minor, they have to use reasonable care in offering that service, and they have to obtain consent for certain kinds of processing. I will skip over the detail of that section just because I don't think it's super relevant to you guys. But what obligations do controllers have on this act? And this gets to exactly your question. They have to provide a privacy notice that sets out the purposes of their collection and processing. They have to process personal data only as reasonably necessary and proportionate to that purpose. So they can't just disclose to folks a purpose and then start going way beyond the scope of that purpose. They have to be limited in some way. That's your data minimization principle. They have to establish data security practices. They have to provide consumers a way to revoke consent and submit requests to exercise their rights. They have to obtain consent to process for purposes that are not the reasons for that collection that are not reasonable and proportionate to that disclosed purpose. They have to obtain consent to process sensitive data, which includes that financial information. It also includes, importantly, consumer health data, which is things like sensitive data is also biometric data. It includes genetic data. That may be one where we actually pull up the text and talk
Yeah,
about the
we can do that.
definition. Controllers also have to obtain consent to process personal data for targeted advertising, sale of data, or profiling to make significant decisions for folks who are between the ages of 13 and 16. May sound like an odd group, but that's because the children's protections are dealt with separately. Children's data is considered sensitive data, and therefore controllers already have to obtain consent. So this is increasing controllers' obligations to secure consent for certain heightened practices for those 13, 16. Controllers may not discriminate or retaliate against a consumer for exercising their rights. You can imagine businesses saying, we're only going to provide you certain loyalty programs or certain things. If you don't exercise these things, they're not permitted to do that. They are permitted to have loyalty programs, which require collection of data, but they cannot retaliate against the consumer. And they must take reasonable measures to ensure that certain kinds of data that are maintained in forms that may be already protective of consumers, so de-identified data or pseudonymous data, they have to have certain contractual commitments with third parties that they interact with to ensure that it maintains security in those instances. So
Pseudonymous, it's a good word.
I hope that I pronounce it correctly because I have no idea. I've just
Sounds.
sounds good.
We did,
Um,
we did.
Another key actor that we should talk about is processors. So controllers are who is mainly the folks who are really the subject of this act. That's businesses who are interacting with consumers, they're selling their data, whatever it might be. But processors are entities who are acting on behalf of those controllers. So they are someone who is in a relationship with the controller, but they may be actually doing the actions of processing that person's data. So processors have certain requirements that apply to them as well. They have to assist that controller in meeting their obligations, and they have to listen to the controller's instructions. To the extent that they don't listen to the controller's instructions, they start kind of going off on their own path, they would be deemed a controller and therefore subject to all the things that we just talked about. So they can't escape the restrictions of this act. The other thing that they have to do is they have to enter into a contract with the controller, and this is the real mechanism for ensuring processor compliance with the act. They have to enter a contract with the controller that governs the processing, establishes a duty of confidentiality, and requires deletion or return of that data at the controller's direction, or at the end of services. So once their contract expires, they have to delete, return that data, or if the controller says, we've still got this contract in place, but I want you to get rid of this information, they have to comply with that as well.
We have a question.
Can you give us an example or a name of a processor and a controller?
A controller could literally be any business. It could be Starbucks has processed your data and then it has collected your data and they want particular things to be done with it. Maybe they want to advertise on the basis of the fact that you bought a particular drink there. A processor would be a third party who Starbucks releases that information to. And if they're selling to, say, other companies that might, or Starbucks is directed, I don't know who this third party would be, but another entity that's going to use it for separate marketing purposes or something within the scope of Starbucks direction, that would be your processor. Someone exclusively acting on that.
Can I ask a question that I'm not sure it's related to healthcare, but it might be? So it could be, for example, a hospital that has a segment of its hospital that is a development office. Could the hospital use patient information to send out requests for donations to a fund within the hospital? I'm trying to look at that. I'm trying to look at something that relates to here. So got a hospital, we do love our hospitals in here. I'm just trying to sort out if patient data could be used by that hospital by the development office to reach out and ask for donations, and who's the controller is the hospital, and then they could just have somebody working as a processor, hiring someone to sort out the data and send out a request. Is that what we're talking about?
So I think there's two answers to this. One, I don't know definitively. One is to look to the exceptions. So, and I pulled it up on the screen, and if it's helpful, this is on page 16. And we're talking about line 14. So the act does not apply to protected health information that a covered entity or business associate, which I think your hospital would meet its definitions under HIPAA, processes in accordance with or documents that they generate for the purpose of complying with HIPAA. So to the extent that what you're talking about constitutes protected health information and is being done in accordance with HIPAA, which I don't know that that kind of action would be. But to the extent that
But wait, would be what? That kind of action would be what?
would not be subject to this act because the idea is that it would be subject to HIPAA. However, my guess is, because I don't, understand how HIPAA works, I'm guessing that that kind of activity is not covered by HIPAA. So what you're talking about is consumer health data, which is a kind of sensitive data and therefore requires opt-in. The consumer would have to provide consent to that kind of processing. I think that's the
Okay,
likely.
that answered my question. Okay. Well, we'll have to go through this again.
Yep, and sorry.
I'm sorry, I'm assuming under HIPAA, they couldn't take the data from patient data and then use it in a fundraising.
No,
It has to be done in accordance with HIPAA, and I wouldn't think that HIPAA would facilitate that, but we are just guessing.
right.
Use the names. Could they just use the names? Could they
Don't get
just-
scared.
Couldn't they use the names though? The names, address, phone numbers?
I don't think so.
I don't think so.
HIPAA does not allow that.
As part of the patient record.
Okay.
It's different if you go out into the community and you're talking with people and you get business and other people in your development office. That's different, and that's not patient information.
So, just to call out the last pieces here, how are the protections enforced? There is no private right of action. There was a private right of action in the House bill. Violations are deemed a unfair and deceptive act, so that's triggering consumer protection, Title IX, but enforced exclusively by the Attorney General's office. And the AG may grant a cure period to businesses so that they can, if the request is delete and they just haven't done that, they could delete. And then we don't need to go into this AI council, but there's some oversight related to enforcement and development of education and outreach. Of main relevance to you guys is, and I will jump down to this section, although I think we're going to be coming back to some of the text. Section 20,
So does the AI council, is there any language in there related to healthcare?
there's nothing specific to it, but what they are developing is policy recommendations on data privacy, which would encompass health data to the extent that it's picked up by the act. So you're correct that they could be discussing health related pieces, and I don't believe that the composition of that council we could confirm. I don't think that it has a health member. That's
Oh, we need to look at that.
so we can actually get to that pretty quickly after this, after I call out the next.
And I'll tell you why. I mean, I've had concerns from people with, for example, MS or rheumatoid arthritis, and somehow their information's been accessed. And then they've been invited to lunch and they've been sort of lobbied about changing the prescription that they have. It's not any of our local, not our insurance companies, not our providers, but larger organizations that would meet that threshold. So
Okay.
there's something, unique and different,
Yeah, I have not heard
very
that.
concerning, yeah.
Your last comment on consumer health data is prohibition on geofence. Can you remind us what the geofence?
So I was about to jump to this section. So this section is super important to you guys, and to call out, this is section 2426, which I also have up on the screen right now.
What page?
This is on page 50. And just, I'll answer your question, but to go through first what this section specifically does. Again, I want to call out those thresholds, the 25K Vermonters controlling or processing that data, or deriving 50% of revenue from sale of data, do not apply consumer health data. This is no threshold for this piece. Any person who is conducting business in Vermont or targeting products and services to Vermonters is subject to this section. no thresholds for this section. So heightened protections for consumer health data. No person shall provide any employer or contractor with access to consumer health data unless subject to a duty of confidentiality. Provide any processor with access to consumer health data unless that person and the processor comply with section 2421. Section 2421 is what sets out the contract between processors and controllers. And the reason it has to be called out here is because we've stripped those thresholds. It's possible that you have a person here who isn't otherwise subject to that section. So person subject to this section, ensure duty of confidentiality, ensure a contract is in place. They shall not use a geofence, which is using technology, and I can actually let me jump to the definition just so you have the specific language. Any technology that uses GPS coordinates, cell tower connectivity, cellular radio, set of technologies, or any other form of location detection to establish a virtual boundary. So this is as if someone's using technology to demarcate an area. And let me jump back to the text here. A virtual boundary within, in this case, 1,850 feet of any healthcare facility, mental health facility, or reproductive or sexual health facility for the purpose of identifying, tracking, collecting data from, or sending any notification to a consumer regarding their consumer health data. So this is meant to get at folks going to have an abortion done and someone's trying to track them by establishing, you can imagine, say, out-of-state entities, or there could be folks here as well, who want to know if someone is seeking these services. And so they use technology to establish a virtual boundary around any of these kinds of facilities, and then they can track basically when someone arrives at that facility and is doing particular things. This is meant to stop that. That's the idea behind this.
No, I'm thinking about some of the satellites that can read license plates from the. But anyway.
So I will say, that's the satellite. I don't actually know that, and then this goes to the geofence question. I don't know that that's technically a geofence. If it's just something that happens to have an ability to see something, it's different than establishing a boundary. Although there might be argument as to how that works. So that's an interesting question. Because I do take geofencing meaning that someone's established like the kind of set up something. It's not just that. Yeah. Additionally, under this chapter, no person shall sell or offer to sell consumer health data without first obtaining consumers' consent. So no sale of consumer health data, and this is to that point as well, if the hospital tried to relay or sell that data. I will jump next.
I do have another question regarding that personal data privacy and the opt-out, going back to that piece.
Mm-hmm.
We currently have rules regarding opt-in, opt-out for our clinical health data through our clinical collection process known as VITAL. And there's an opt-out in that. So we'd have to have something that says we already have this. We don't have to go through that again.
Mm-hmm. I think this is again an exemption question.
Yeah.
Because just to call out what the idea is behind the exemption section, it's not obviously to reduce the protections of the Act. What the section is meant to do is recognize if there are independent privacy regimes in place that are already protecting consumers' privacy, and that you don't want to disrupt those already existing regimes for businesses, hospitals. Exactly.
Time cost.
So the idea behind it is to the extent that they can be narrowly crafted, and that's why you'll see data level exemptions as opposed to more entity level exemptions. The focus has been on trying to capture those independent privacy regimes without just permitting certain institutions to operate as they see fit, basically. So trying to balance independent privacy regimes with ensuring that we're not letting something slip through the cracks, but we also don't want to duplicate existing. So the piece that you see here, and this is on page 16, same language we talked about earlier, protected health information that a covered entity or business associated processes in accordance with, or documents that a covered entity or business associate creates for the purpose of complying with HIPAA. If we're talking about, I think your hypothetical potentially could be captured by this, but I'm not positive. And so we may need to it will be helpful to get health industry folks, obviously, to testify on what HIPAA.
I think HIPAA does protect what we have, but we also have in statute
Oh, okay,
very
okay.
explicit opt-out language related to
Okay. So I think that unless the folks who would be captured by that opt-out are independently captured by one of the exemptions, I think you probably do need to work around what you're talking about. Because we don't have any specific carve out for what you're discussing.
You're talking about an exemption for that.
Yeah, I would just say that that's not something I have seen. So
Okay.
if there's a section I need to look at
Okay,
to make sure we aren't duplicating something. It could be that any entity that would have to comply with that section is already picked up by one of these other things, in which case it doesn't
certainly,
matter.
yeah, I think you're probably right.
But to the extent that someone is not, yes,
Yeah.
we would want to. There's a last section as well, which is not relevant to you guys about data brokers, and there's nothing specific about health data there. So with that, that's kind of the overview of what the act attempts to do. I'm happy to dive into particular things, or given time constraints, I can call out. And I will just go through the definitions section while I do this, so you guys can see places where you should focus your attention, and I will say why.
Let's do this, let's do the definitions, those where we can center our attention, and then the sections that are relevant.
Yep.
To us, that would be great. Question.
Just out of curiosity, if there's any competing bills on the same topic coming in at the same time, or if this is the focus
This is
for the
it.
end of, okay?
This is it. The only other one would be the one that's up there, that we can start over with, but we are doing. Senator Williams had a question.
You mentioned no private right of action. And also that the Attorney General is gonna be enforcing part of this. So I've had personally been notified by two different medical institutions in the state that my data was. And so I contacted the Attorney General's office, and in the mail, I got a brochure on protected privacy. So are we making another bill we can't enforce? Or that we don't have any intention of enforcing?
So I can tell you that the AG, I don't want to speak on their behalf, but just based on testimony I've heard, they are invested in enforcing this act. So this is not, this is something that's meant to have implementation. This is not just for show, is the way that I would put it. However, you are correct in the premise that removing the private right of action limits folks' ability to enforce their rights, because what it means is that we're constrained by resource allocations to the AG's office. That's basically the effect of not having a private right of action. I'm sure that they will talk to you about that. But this is not for show. There are real enforcement mechanisms in place. It does permit businesses to cure. They're permitted some period in which if the AG determines that they deserve a cure, they would have a period to fix the problem and not face enforcement action from the AG. But the AG does have the ability, and the intention, as I understand it, is for there to be real enforcement of these provisions. And it's a little different than just data security breach. This is a whole set of rights that are afforded ways. It's not just one thing that can happen to, it's a whole host of things that can happen. So I will jump to definitions, and I'm gonna, so starting on page 1, but I'm gonna call out things that are relevant to you guys, and then core concepts as well. So I looked at this quickly right before I came in. I think abortion, which sounds relevant to you guys, is actually now superfluous in this draft because we've removed some of the language that requires this definition. That's not to say that the concept of abortion is not relevant to the act. It's just to say that I don't think we actually need this defined term, and I'm happy to explain why that's the case. In an earlier version of the bill from the House, we, in certain sections, would call out concepts like healthcare facilities or healthcare data. And we would give a general concept of what that might be, but we would also spell out a whole list of things and deem them to meet that standard, just to make clear. They probably already fit the concept, but they wanted to deem them to be the case so that there was no question as to whether or not abortions or certain things would meet these restrictions. That's not been seen to be necessary in other states, and we don't have to call those pieces out. It was just kind of like an extra belts and suspenders type approach. So that's why I'm saying abortion could be deleted here. It's not to say that abortion doesn't matter for this act. It does matter. It's just that we don't need to think about that. We don't need the definition here. So with that, I will jump down to biometric data, which is on page 2. This is in the health realm. This is not limited to health, but health biometric data, which is a kind of sensitive data, is personal data that's generated from technological processing of an individual's unique characteristics, biological, physical, and physiological, and that is linked or reasonably linkable to that individual, including irises, retina scans, fingerprints, vein patterns, gait, the like. So what this is technology that can capture someone's distinctive features and is used to identify them. That's treated as sensitive information. It is important to call out, and this is a distinction with what is in the House bill. Biometric data does not include photographs, audio or video recordings, or data generated from those photographs or recordings unless used to identify a specific individual. I call this out just because this could feasibly overlap with health. It is not strictly a health measure, but if you think of certain physical characteristics being used as the basis to identify someone, you could imagine that certain kinds of health data, if someone, has an ambulatory disability or the like, might be a way of identifying them. So I just wanted to flag that is something you might want to think about. And again, this is a kind of sensitive data, which means consent is required for processing of this kind of data.
That's the question.
Yeah,
I know there are a lot of apps that track women's menstrual cycles. Is that included in any of this?
That would be in consumer health data, which we'll come to next. Yeah, I don't think it would, I mean, I don't know enough to say how that would work. I guess feasibly, that is a kind of technological processing, if it is unique to that person and is to be linked to them, I would say that it meets the concept of this definition. I haven't heard that referenced in the biometric data context. And because I think it's readily picked up by other definitions, maybe the question doesn't. Maybe it's insignificant if it meets the biometric definition, but I think there's an argument could be.
Yeah, that's what I was thinking.
It's an interesting question, they do thought can take you different places. Yeah.
If we turn to page 4, actually, sorry, consumer health data. This is any personal data the controller uses to identify consumers' physical or mental health condition or diagnosis, including gender-affirming health data and reproductive or sexual health data. I think this is much more readily where that would fit. As a condition and would fit into likely reproductive or sexual health data. We have additionally as well this subdivision 11 on line 8, consumer health data controller. This is just any controller, so that's the businesses complying with this act, that determines the purposes and means of processing consumer health data. So this is just a way of calling out those entities and saying, when we're talking specifically about consumer health data controllers, we're wiping away those thresholds and we're having heightened restrictions for consumer health data. So that's why that concept is included. Just to call out, because I haven't defined what controller is. It's a person who determines the purpose and means of processing personal data. This is a very big concept. Someone doing something with your data, they're determining why it's done and they're directing someone to do it. That's what this is meant to be. It's intentionally quite big to capture all kinds of activity with data.
I'm just want to ask a quick question.
Go
I'm
ahead.
still curious, like, what's a company that does this work?
If any business that
Oh,
so they take-
wait, I'm thinking of the other one, the processor. Never mind.
yeah, so a controller would be someone takes your records the fact that you ordered a particular drink. I mean, there's all kinds of things that you
Right,
can
sorry.
do with it.
Yeah, thinking more.
And we will come to processor, but
Got it.
next is gender affirming health data, which is on page 6. I'm jumping past a bunch of stuff I realize, but hoping to call out just the relevant pieces. Gender affirming health data is any personal data concerning a past, present, or future effort made by a consumer to seek or consumer's receipt of gender affirming healthcare services, including precise geolocation data that is used for determining a consumer's attempt to acquire or receive those healthcare services. Efforts to research or obtain gender affirming healthcare services.
What page is that?
This is page 6 and 7. Yep. And any gender affirming health data that is derived from non-health information. So gender affirming healthcare services, this is relevant for those healthcare facilities around which we have a prohibition on geofencing in that section 2426, which is for consumer health data.
So that would include data that is embedded in a school system about a kid.
It could,
Yeah.
it could, yes.
Okay.
So healthcare services is linked to calling out those facilities on which prohibition on geofencing is established. Health data which we
There's
just
also genetic data, which is.
With genetic data, geofence, healthcare facility.
So genetic data is another kind of sensitive data, and so requires consent for processing of that data. Geofencing, which we've talked about, but just to link in, that's technology that uses GPS or other location detection services to establish a virtual boundary. That's pulled into that section 2426 prohibition on geofencing around healthcare facilities, reproductive or sexual healthcare facility, gender affirming healthcare facilities. So that's why that concept is in place here. Healthcare facility, this pulls in existing Vermont definition. Again, this is for that geofencing prohibition. We can jump to mental health facility, which has a very similar, it's the same import for this. Mental health facility is on page 9. Line 4, subdivision 32, any healthcare facility in which at least 70% of the healthcare services provided in the facility are mental health services. I will say there have been repeated questions as to how that figure is arrived at. It's somewhat arbitrary, but what I will say is in terms of practical import, a mental health facility is a health facility. And therefore the prohibition on geofencing around health facilities will already pick up this. This is, again, I see this as a belts and suspenders. And if you want to look at this piece, I would try to consider it in interaction with the existing statutory definition of healthcare facility to make sure that you're not, if you get rid of this or change the threshold, that we aren't accidentally dropping some mental health facility that wouldn't be adequately picked up by the definition of healthcare facility. I don't think that you will find that. I think you're safe, but that's why this is
How is 70% derived?
arbitrary. It's
Arbitrary.
arbitrary. I mean, this is an approach taken in other states, but there's no,
Yeah,
right, you could have all kinds of different thresholds.
and that one might be something.
Yeah. We can jump to precise geolocation data, which is on page 10. This is line 8, subdivision 38. Precise geolocation data is personal data derived from technology that accurately identifies in this radius consumer's present or past location, or the present or past location of a device that links to them, or any data that is derived from a device that is used or intended to be used to locate them. So this is, again, this is a kind of sensitive data. Consent is required for processing of this data. And this is tied into those ability. If folks are tracking people either to go to particular facilities or just you're walking around, and you may have an app open or something to that effect, securing consent just so people aren't randomly tracking where you happen to be. That's part of what animates the idea behind including this concept here.
They find it very boring. Sorry about fight.
Oh, it's just going across the hall and bathroom.
I just quit.
Oh, it's just getting coffee.
We got very serious.
People have all kinds of
Yeah, I
strange
know.
interests, so people might be into that. I don't know.
Oh, my.
With that, I should call it. It does not include content of communications or data generated by utility metering infrastructure systems. This is kind of like an inbuilt exemption is the way to think about that for this definition. Should not disrupt utilities. Processors. Okay, so we're coming to process or processing. This is a happy moment.
Super happy.
So processing any operation or set of operations performed, whether manual or automated, on personal data or such personal data, and then such as, so this is just indicative list, collection, use, storage, disclosure, analysis, deletion, or modification. This is really like anything you do to data is processing. It's a very broad concept. And what is a processor? That's on the next page. It's a person who processes, but they do it on behalf of a controller. So it's someone who's in a relationship with a business. If your question is, who are these third parties doing this?
Yes.
I don't know the names of folks who do this, but there are likely all kinds of third parties out there who provide data services. Like that's their job. Is they're not necessarily, they could provide direct consumer services like a Starbucks does. I hope that I'm helping.
You are.
Do you know, have you heard the commercials all the time? Business to business e-solutions.
Sure, that's what they are.
There they are.
They're the people who like take the data from one business, process it, and then use it for something else.
Sell it.
And it could be
Yeah.
a reporting agency, the reason that I'm describing it in part abstractly is that anyone could be these, so Starbucks could be a processor if they received data on behalf of someone else and then did something with the data at their direction. So I could name any institution, but that would also not give you any help
Right.
in understanding what it is. Like, the point is just someone who is who's doing things to data on behalf of someone else, and it could be a credit reporting agency, it could be Equifax, it could be a company, it could be Starbucks. You know, but the reason I hesitate to call out that particular thing is, there's nothing inherent about Equifax that makes that more of a processor than someone else. Anyone can be a processor if they're just engaging in processing.
Okay, thank you.
I hope this.
No, it is.
Yeah.
So I'm looking at profiling and what clicked with me when I read that was the biometric sort of exemption or elimination of audio, visual,
Mhm.
photographic. I might want to come back to that.
So, you wouldn't need it to be in the concept of biometric data to get at profiling in the fashion that I think you're describing, because profiling is any form of automated processing that's performed with personal data. So yeah, understanding the question. If your concern is that, photographs could escape restrictions on profiling, which profiling for certain significant decisions requires that opt-in. I don't think there's a concern that you would be dropping that by not including photographs and biometric data, because the key item here is personal data rather than biometric data for purposes of this definition of profiling.
Okay.
Is that responsive?
And it does help.
Yep.
I'll still come back, I'll go back to the other question.
You
Senator
see,
Weed said the question.
okay,
Yeah, just kind of a generic question. So based on previous projects I've been involved in, it was important to maintain access to some elements of the issues that you're talking about here for law enforcement or intelligence purposes. Where does that bump into the,
so the piece that, and I can jump to this, or I can just call out. Section 2424 is where you're gonna wanna look. It's the construction, it's essentially the construction of statute section, and what it tells you is ways not to construe the chapter. And one of the pieces that it says is that ordinary force operations, law enforcement can perceive that this act is not meant to restrict their ability to perform their obligations. And we can jump to it
no?
in a couple, but that's the
I'll-
section that's relevant to you. If the question is there an exemption for law enforcement? There is not an exemption for law enforcement entities. The way that particular concern is dealt with is the construction section. So that's where you would want to look, is 2424.
So what I'm thinking is, if we can finish going through briefly the definitions and then just give us the numbers of the
Yep.
sections, and then we'll come back to it.
Yep. I don't think we need to talk about protected health information that's related to the HIPAA exception and is a HIPAA term. But the next piece we want to look to is reproductive or sexual health care. This is bottom of page 11. This is tied into your reproductive or sexual health data and reproductive or sexual health facilities. This is again, sensitive data, so processing and prohibitions on geofencing. That's why these concepts are coming up. Reproductive and sexual health data is any personal data concerning past, present, or future effort made by consumer to seek or receipt of reproductive or sexual health care. And as you can imagine, for these facilities, we have that same 70% threshold. A healthcare facility that is providing at least 70% healthcare related services or products rendered or provided.
And we get that 70% again. And
Exactly.
it came from somewhere.
I think it's just the way that
Other
others
states.
states, but I think that you don't necessarily need these concepts for the prohibition on geofencing, because I think healthcare facility already captures these, but something to think about.
Can I ask a question?
Yeah, go ahead.
So, and as a number 47, the reproductive and sexual health data, that data would be exactly the kind of data that Senator Bueller was talking about with the period tracker apps.
So that would be a kind of consumer health data.
Exactly, but people use those apps not necessarily because they're seeking medical care. they use them because they're trying to track the periods.
Yeah.
So is with that,
So I think it still meets so I think it fits the definition of consumer health data, whether or not it meets the definition of reproductive and sexual health data. Because what the definition of consumer health data says is identifies a consumer's physical condition if used to identify the person. So you could have a question on the second piece, and maybe I see the face at physical condition.
Yeah.
But
I just wonder if number 47 is used for higher protections under the bill. I would want to make sure that the example that Senator Gulick mentioned is included in this, because that is a person sharing health data on an app, but not for the purpose of seeking
Right.
healthcare.
so,
Yeah.
yeah, I think that's a good question. I think the question is, does it meet either of those two definitions? And the reason it matters is it becomes sensitive data and it is therefore subject to higher protection. So
Well,
I think there's an argument that it does meet the definitions, but point taken, and those would be the two to look at, is consumer health data and reproductive or sexual health data if you're trying to resolve that question.
Yeah.
right, so, and legislative intent would be included, that it is included, but we won't,
So you could,
we might put something in there. Okay.
let's jump to sensitive data, which is, we've been talking about all this time. This is a laundry list of items that are subject to this opt-in. So we are on page 13, line 8, subdivision 50. Sensitive data is personal data that reveals a consumer's government issued identifier, and this is going to be just a laundry list of items. Reveals consumers' racial or ethnic origin, national origin, citizenship, beliefs, union membership. Reveals consumers' sexual orientation, sex life, sexuality, or status as transgender or non-binary. Reveals a consumer status as a victim of a crime. Is financial information. This is responsive to an earlier question, including consumer's tax return or account number, financial information, debit card number, credit card number, in combination with security access. It's consumer health data. So that's the piece we've really been talking about all this time. And there is another piece related to this consumer health data. You will recall that the definition of consumer health data requires that that information be used to identify a particular person. But we're picking up here in sensitive data, even information that isn't used to identify. So that's what your subdivision G is personal data collected and analyzed concerning consumer health data, or personal data that describes or reveals a past or present, future mental or physical health condition, treatment, disability, or diagnosis, including pregnancy, to the extent the personal data is not used by the controller to identify a specific consumer's physical or mental health condition or diagnosis. So this is the language you see there is the same as what's in consumer health data, except the last piece, not used by a controller to identify. So it's saying even when a controller isn't using it for those purposes, that kind of information is sensitive data. So I think that you're safe on the hypothetical areas, but I take on that. Other sensitive data, biometric or genetic data, personal data collected from a known child. So there is a mental state built into this. The controller needs to know that they received it from a child. Is a photograph, film, video recording, or other similar medium that shows the naked or undergarment clad area of the consumer. This is not something that's been included in other states, but you could think of it as like classically sensitive data. It's private matters. And precise geolocation data, which we've talked about as well, as a kind of sensitive data. That's really your core concepts here. So let me call out, I realize we were running back against time here, but I think we've actually got through a lot of stuff. The only health data specific section, like exclusively health data, is section, 2426. So you will want to look at that. We've already talked about these prohibitions, but that's where you're going to look for health specific pieces. The other pieces you would like to pay attention to is look to at 2416, the applicability section. We've already talked about this. I just want to call out. This is on page 15.
What page is 24, 26 on?
I think that's 50.
Yeah, it's,
50, yeah.
yeah. 50.
So 2416 is applicability. This is where you're going to see that those thresholds don't apply to consumer health data. We've talked about that. I just want to flag the language so you know where to look. 2426 on page 50 is the consumer health data restrictions. You're going to want to look there. Otherwise, you have to look generally throughout the act, but I can tell you places that are helpful. So 2418 is your consumer rights. That's gonna set out the rights that consumers have and also what controllers have to do to comply with it.
Page is that? Sorry, just going back there.
2418 is on page 22. This is gonna be generally applicable stuff, so this is not exclusive to health data, but just so you see what kind of rights are afforded and how controllers are meant to respond. I think what's gonna be useful for responding to some of the questions that you guys have is looking, I don't want to just give you every section, but then it becomes useless, but, 2419, and I will give you the page number.
27, got it.
27, that sets out duties of controllers, so that's gonna tell you the ways controllers are limited, and that tells you specifically one of the key pieces we've been talking about all this time. On page 28, we say a controller shall not process sensitive data without first obtaining the consumer's consent. That's really the core concept we've been talking about all this time, so that's language you want to be aware of.
Which section was that?
This is section 2418.
Oh,
Sorry, this is section 2419,
And
and
page,
it's on page 28.
yeah.
And if it's helpful, the subdivision is B2. That's what you want to look at. The other thing that's been responsive to some of the questions, including law enforcement pieces, is the construction section, which is section 2424. That's on page 43. This tells you ways not to construe the act. And I know that, and this is maybe a good place to end on the act. A lot of the discussion is going to be 2417 exemptions. This is 2417 is where we set out for our exemptions. And so you're going to be looking at likely the exemptions that are contained at, this is on page 16, starting on page 16, 2417A 2 through 8. The exemptions at 2417A 2 through 8 are all health related. 2 is your HIPAA data level exemption, so that's the main one you're going to look at. The other ones are kind of ancillary, but they were taken from other states that also try to address health concerns. That's the high level overview of places you should look, but I'm happy to talk about things in more detail as helpful. And if you have things you want more information on, I can try to figure it out.
Okay, so what we'll do is, we'll invite you back in. We will read through these sections on our own. And we have a letter from, a large group of, healthcare folks with concerns about the bill, so we'll read that. And then we'll invite you back, maybe as early as Friday, I don't know what
Okay.
that's the paper.
Sounds good to me. And I guess I can find that posted on the y'all's committee webpage.
Yeah, is this posted on the webpage? Yes. Yeah.
Okay, I'll look there if I feel inclined to figure out what people want. Yeah. Perfect.
Well, I think nothing like a short, little, simple bill.
From my perspective, I think we did like a nice job, and I'm saying compliment myself on that. So
Nice job.
You did it.
I think we got to a lot, relatively clear.
No, this was helpful. Thank you.
Cool.
I've been waiting for this one. This is.
All right. Yep. I'll see you guys.
Thank
Thank
you.
you.
Yeah. Good to guys. Nice to meet you.
You too.
Okay. So, clear your minds a little bit. We're moving on to S 766, and I understand Senator Brock, you have a proposal amendment. You want to come up and, do we have copies of that or?
Right here,
All right.
one copy for everyone and one for your basis. Thank you, I'm Senator Randy Brock, and I'm here regarding the proposed amendment to H 766. It is the perfect amendment because everybody who's affected by it is a little dissatisfied with it. And that suggests that it's a winner. It is designed, in a nutshell, to take H 766 and try to address the concerns that what essentially has become two sides of this issue have, and come to a middle ground that deals with the urgency that the providers are requiring in terms of getting action so that they aren't on hold for 2 hours or 2 days or 2 months in order to get an answer on a prior authorization on the one hand. And on the other hand, it's designed to address the concerns of insurers that we don't go into uncharted territory in some cases that no state has done without clear understanding of what this is going to cost and who it's going to cost. And if there are any savings, where are they, how to quantify them? It addresses the concerns of many of the folks that we've spoken with in the committee and also outside of the finance committee. Again.
So I want to ask you a question.
Yes.
This is your own,
This amendment
amendment.
is my amendment. It is shared, it's joining me on the amendment as it's been proposed today will be Senator Cummings, who is joining the amendment. There may be others, I don't know, but obviously this is a fast moving amendment.
And then, so if you could show us exactly what's being recommended.
Correct.
And
What I
then
did,
with our time is.
yeah, what I did is I gave you a strike all, and the reason I used a strike all is to make it clear as to what's actually happening. And those things that are changes from the amendment that you've looked at are in yellow. And that's where I would just emphasize is are those changes. Among the points in all of this is that the vast majority of what's in the bill that you've already looked at remains in there. Go to, let's see, first.
What we'll do is we'll have you go through it and we might ask Jen Carvey to also.
The first group of yellow changes appears on page 12. It deals with prior authorizations. And to make a long story short, it says prior authorizations have to be done within 24 hours, period. That's what it says. It says that rather than going on hold in the bill, you'll notice that you have emergency prior authorizations that are done in 1 day and then 2 days for all. It says all, so that the prior authorization doesn't get hung up. Now, one issue that is not addressed in the bill that I know some of the insurers have talked about, and this may be an issue that goes to a conference committee to deal with, is just, we're under the same time pressure that you all are. Is to deal with out of network situations, because they do have out of work. This example, let's say you have a doctor in San Francisco who's an individual provider who's not part of any network, and just going back and forth between the insurance company and that provider, they think they may need, under pressure, 2 days to do that rather than 1. So that's still outstanding. See what else we have here. If that essentially those 2 pages that deals with that issue of prior authorization. Page 17 of this Department of Financial Regulation, the issue of an actuarial. That's the piece that's missing, and we heard from DFR immediately afterwards that they can't even opine on what this is going to cost or who it's going to affect, or whether we save anything or whether we spend something without an actuarial study. They have a contract with the actuarial firm to be able to do this kind of thing. So there is no cost that will be added to the budget by doing the actuarial study. And what this does, beginning with section 6, is it says they're going to be charged with doing the actuarial study and then coming back to the committees of jurisdiction with their recommendations. And it delays the implementation of the other aspects of this for 1 year to allow that actuarial report to be done, and then for the committees to make a decision on what changes, if any, will be made to what's being proposed as a result of having facts. That's probably the biggest problem that we see with the bill, is we're making decisions that are really, not going to say monumental, but they're very consequential, and potentially they could cost millions of dollars, both in software changes.
We understand.
Okay, the issue is, let's do it understanding the facts and having some numbers that we can rely on.
So what did the DFR give you a suggestion of how much they need further in the budget in order to
They
do
did
this?
not say that they needed anything. They said that they have fund assigned to do actuarial studies at a firm retained to do that on behalf of the department. So they were not asking for any additional money. I could give you other details about what's intended and so on and so forth. I think this is pretty clear. This provides an interim means in order to address the provider's concerns of being kept on hold and not getting any response on the one hand. And on the other hand, it provides the carriers with the certainty that A, we're not going to do things that are going to be extremely costly and disrupt things without having knowledge of what it is we're doing and why. That's it in a nutshell. As I mentioned, Senator Cummings has joined me on this, and I don't perhaps have to tell you of all the people who are writing with concerns, but in addition to the providers who are asking and the insurers who are asking, we're hearing significantly from business that this is a concern about untested policy. We've heard from Associated General Contractors, Associated.
So we did
Industries,
hear
so-
from them, thank you,
Okay,
and,
fine.
but what I also know is that perhaps some of those businesses are not included because they're ERISA plans or something.
That's correct. And
So, I mean, so you can't take all of that, as it is, but
understood.
yeah, I get it, I understand. You've heard testimony and you've made a decision there, so as I'm looking at page 12, you have, we'll bring Jen up and look at the effect that it's had on prior authorization, which is a big chunk of where you're suggesting changes and then asking DFR for actuarial analysis.
Deal with the current problem and put at least some sort of a Band-Aid on it to help us get through it and to ease the pain that providers are suffering right now, then make final decisions on the basis of studied information.
So, but you didn't touch the report back from either the providers or payers.
Do not.
And that an actuarial analysis could be a part of that report back. What if, as some of the prior authorization activities take place, did you talk about that?
And did I say that?
Did you discuss keeping the prior authorization particularly in place? And then having the report back and the actuarial analysis being useful?
We did not discuss keeping it in place. Well, it's essentially in place, except it's accelerated. In the original bill, for example, emergency responses come back within 24 hours and the others come back within 2 days, and we made it all 24 hours.
Okay.
One day.
That sounds good.
Well.
Okay.
Can I ask the question?
And then you've crossed out on prior authorization, the section. I think there might have been some confusion on page 13 under C, and we'll clarify that with Ledge Counsel, but the more than 1 year is for the prescription, because all medications are required to be evaluated after a year.
Yeah, I believe
And
you
then the
dropped the
5
5-year piece.
The
Yes.
5 year piece
Yes,
was my understanding that the payers and others worked on this section together when the House was meeting, and the payers actually suggested the 5 years. So
We had concerns that we heard, or at least that I heard about the 5 years. The 5-year period was simply too long, with just given the amount of change that occurs in.
that's different from what the decision was made by the group that worked on this. So that's interesting that it would happen. And then, so then the non-urgent 24 hours. Okay, we'll have to look at this with Ledge Counsel, but you've done a thorough job here. And then we'll sort it out, because we've also done a lot of work in this bill. And we've heard a lot of testimony, and we don't want what has been happening to continue or to ever happen again, and that's one.
And that certainly was part of the goal of what I was attempting with this, is again, to strike a middle ground, at the same time, expedite things so that providers aren't suffering the way that they have been.
Okay, thank you. Good, thank you. Wait, Senator Bullock, did you have a question for Senator Bullock?
It's just around how these companies are suddenly gonna change the way they do business and how they're gonna do business to get to that 24 hours. It just seemed, I'm just curious, that's all. But that's maybe a conversation for a different day.
It's obviously with providers. I've spoken with at least Blue Cross and MVP, and I'm not sure that they're entirely happy with that as a solution, but it is not an impossibility based on what I've been told. Not an enthusiastic acceptance on one. Yeah. Thank you very much.
Thank you, and thanks for coming in. All right. So Jen, do you want to?
Yes, well, we need.
Okay. Walk us through and remind us where we are in the sections. Like prior authorization had a couple of different things. One was on timing, one was on. Prior off.
Right, do you want me to put this up? on
Yeah,
the
let's do
screen?
that. Please.
If you, I may need an invitation.
That's all they.
Are the dots all gone?
Yeah.
Sorry. My snack drawer is comes.
I can
to
make one of
rescue.
these.
You're good with that? Okay.
Yeah.
Yeah, that's my lunch.
They had granola bars all day.
Well, we don't really have lunch today.
No, we don't. So,
I know, we don't get one. That's why. We're gonna have to come back to this proposal amendment, I'm pretty sure, unless we can make a decision quickly.
Okay, so I will put. Jen Carvey from the Office of Legislative Counsel. We're looking at H766. This is Senator Brock's amendment that he's indicated Senator Cummings will be joining as well. I'm showing you still the markup version, which is the same version that you have. And so the bill doesn't make any change, or the amendment doesn't make any changes until page 12. So the first section is the step therapy. There are no changes in the step therapy section. So scroll through that. Section 2 is processing claims, downcoding, and adherence to coding rules. This is what we've often referred to as kind of claim edits section. There's no change to the language, but the effective date is delayed for a year. So instead of taking effect on January 1st, 2025, in the effective date section, you'll see I carved this one out so that the first parts of it, subsections B, C, and D, which are the parts on aligning the claim edits with Medicare, those would be delayed for a year. The other pieces of it around coding validation review, and the working group would take effect as originally scheduled. So that was January 1st, 2025. Section 3 is the alignment of prior authorization requirements with Vermont Medicaid. This provision is also delayed 1 year, which you'll see when we get to the effective date section. So sections 2 and 3 are delayed in the effective date section by a year. And you'll see them be referenced in the actuarial analysis that's required in a later section. Section 4 is the prior authorization timeframes, and this is what Senator Brock was describing as requiring plans to approve, deny, or inform the insured or provider if any information is missing within 24 hours following the receipt for, and I've added for all prior authorization requests and for all appeals of denial of prior authorization requests. And then if the plan informs the insured or provider that more information is necessary, the plan has 24 hours to approve or deny upon receipt of the necessary information. We had that in the version you looked at just for the prior authorization, for the urgent requests. Then because everything goes under the 24-hour time frame, I struck the non-urgent timing. And then we have the language.
So let's look at that.
Well, because everything goes under. the
So now
24
everything is
hours.
under 24 hours, so this becomes unnecessary.
So we don't need, exactly, so we don't
Okay.
need a different timing for non-urgent. Then on page 13, we have the language saying if the plan does not within the time limits set forth in subdivision A, respond to a completed request or request missing information, and we didn't really need to say acknowledge receipt of the request because that was already part of the 24 hours. The prior authorization is deemed to be granted. And then the approval for prescribed or ordered treatment, service, or course of medication is valid for the duration of the prescribed or ordered treatment, service, or course of medication, or 1 year, whichever is longer. And then it takes out that language, that I'm not sure the insurers, I've heard the insurers testify that I think not in favor of the 5 year.
It was a
Period.
5-year piece.
Yes, so the 5 years
The
is struck.
Service, I'm trying to
So-
understand, but my question is different from yours. The insurers don't like it, but I'm trying to sort out why they met with everyone and made that decision and then came in here and made a different decision.
I'm happy to talk about
Yeah, okay, we'll do that.
All right, so this would strike out that five years for ongoing, for prescribed or ordered treatment services or courses of medication that continue for more than 1 year. And then just updates the subdivision numbers. Does not make any changes to section 5. This is a lot of the language around the contract and manuals and policies that supplement a contract between providers and contracting entities. So no changes there. Section 6 is new. This is the DFR actuarial analysis. This directs DFR to arrange for an actuarial analysis of the anticipated costs and potential benefits of aligning the plan's claim edit requirements with those in Medicare as set forth in section 2, and of aligning the plan's prior authorization requirements with those in Vermont Medicaid as set forth in section 3. And would have DFR provide the results of the analysis by December 1st of this year to the House Healthcare and to this committee and the Finance Committee. And then I renumbered the remaining sections 7, 8, and 9, but this proposal does not make any changes to the insurer impact reports or the provider impact reports. And then in what is now section 10, the effective dates, just added in the DFR actuarial analysis as being an effective on passage and the corresponding changes to section numbers. Subsection B is a change that actually I have a standalone amendment to fix anyway. In the underlying bill as it came over to you from the House, there's an error in the effective dates that refers to section 3 with a description of section 4. It should say section 4 with a description of section 4. So I've corrected that here while I'm at it. And then we have new subsections C and D saying that in section 2, and that's the piece on the claim edits alignment with Medicare, those would take effect on January 1st, 2026 and apply to everything that happened on and after that date. And then section 3, which is the prior authorization alignment with Medicaid, would take effect on January 1st, 2026 and apply to everything that happens on or after that date. And everything else is January 1st, 2025 as in the bill you passed out. This version I will also say does not include this committee's inhaler amendment because there were some DFR raised some issues with that, and so.
I saw
I
what
wasn't
they
sure
said,
how
but it
that
doesn't
would
make
all-
sense for what we had heard. We heard that the payers and providers were going to get together and clarify that language based on the developmental level of the kid and what the condition was, whether they needed positive pressure or whether they could inhale. I mean, there's some concerns embedded in that.
Right, I think my understanding from DFR is that we can't distinguish. on
DFR
basis
doesn't have
of
a medical
age.
director. Sorry, I'm sorry.
My understanding from DFR is that federal law does not permit discrimination on the basis of age in the development of benefit design. So we would need to have some other criteria that isn't age-based.
I've got it. Condition-based.
Right.
Yeah, so we could do that.
I believe.
Okay, and then, so as we go through this, we're gonna, obviously, we're gonna have to go through this again, but there are a lot of questions here about the implications of this, not the least of which is the date changes. I mean, it froze everything back, that just went off.
Oh, I took it down, so we don't have.
Okay.
The date changes and then
Bright, light.
the implications of the moving to the 24 hours for everything, what does that mean? And so, and how much it costs for an actuarial analysis and whether that's going to be something that holds the bill up because of money. I'm concerned, I'm very concerned about this coming through now when we're ready to present the bill on the floor. We'll take some time to look at it. Kiki and I will find some time to look at it.
Can I just ask? a question?
ASAP, yes, I've got you right on the top of the list.
Thank you, Senator
Do
Lyons.
that. Right
I mean, I don't
now,
know if this is a question for Jen, but just like looking at this, I circled this paragraph that says if a health insurance plan. If they can't do it within 24 hours, they can just ask for more information. They can always ask for more information.
I'm sorry, where are you?
I'm on page 12, little I.
Yes, okay.
So they can always say to the provider, I need more information, and then that buys them that buys them as much time as they need. Buys them a ton of time, so that it seems to me that this going to only 24 hours would incentivize health insurance companies to say on every single prior authorization, I need more information. And then they have weeks to do it.
good thought.
Some of that may be a DFR enforcement issue. You know, they're supposed to approve, deny, or inform the insured or provider that information is missing and they can't make the decision. They can't make a determination based on the information provided. If that's being abused, I would expect that to be a DFR enforcement issue.
But they don't have that, they don't do the enforcement, they just collect the data. Right now, there's no enforcement. There's no-
Well, they regulate the insurers as insurers.
But would the healthcare provider, some doctor's office have to say, every single time I ask for the prior authorization, the insurance company says they don't have enough information, and then DFR.
That is
would have
how
to
I
do
would
it.
envision that playing out, but
Yeah,
DFR would have a better sense for how it would work in practice or the provider organization.
I mean, because 24 hours is super fast, so I'm assuming that they're gonna be like, we don't have enough information, so we're gonna ask, then get unlimited time.
Well, it's not once the information is provided, the 24-hour clock starts again,
Right,
but I take your point that.
It could go on
that
and
they're-
on
they're
and on.
almost,
and on.
asking for
What
piecemeal
has happened
information.
that caused this in the first place?
right, and then it's sort of it's a drag your feet kind of thing, because they need more time.
Okay. So then. And then the 5-year and Blue Cross and Blue Shield said they can respond to that. Sarah, do you want to comment on that 5-year section?
Sure. Sarah Teachout, Blue Cross and Blue Shield of Vermont. I believe the original proposal was to make prescription prior authorizations good for the lifetime of the medication, so if the person needed it. We find that a huge majority of the medications people are on are chronic, and so for the rest of their life. So I did negotiate down to 5 years from lifetime. Then I went and spoke to Nancy Hogue, who told me, this is no good, this doesn't work at all. So I asked for another change.
Wait, who's Nancy Hope?
She's our director of
She's the
pharmacy,
director.
Oh.
so she's not in the room, with
Okay.
me, and I went back and said, oh, this is what I was able to negotiate, and she was like, yeah. So that's what I'm asking for a change.
Okay, we'll think about that.
Okay, thank you.
I know you brought it up early in the test. Okay, and then can you, Jen? Or Senator Hardy asked. a
Yeah.
question. Oh,
Go ahead.
thank you. Can you tell me again the sections that are now, the dates that are put off? Go through section,
Yes, it's sections 2 and 3 are the ones with the delayed.
that goes to
Effective date.
January 26th.
Yes, they're delayed 1 year, and that's the claim edit alignment with Medicare and the prior authorization alignment with Medicaid.
And all of section 3.
All of section 3, because section 3 is
All
the
the prior-
alignment with Vermont Medicaid.
And that's all of.
Section 3 is on pages 10 and part of 11.
Okay.
Can I ask my question or are you?
Is there anything else missing for that, with the dates?
I don't believe so. There's the actuarial analysis of those that would come back in December and then
And the report timing has not changed, so it includes the 26, 27 data collection by providers and then the other data collection by the insured
yes, the 25 and 26 data collection.
and Senator Hardy.
Well, that was my question. I mean, we already have in the bill two impact reports. What is the impact on providers and what is the impact on insurers? And so it just seems like we're adding a third report that is a report. I don't understand what they're gonna be able to determine in the first report, because something won't have happened yet. So the impact reports will be based on actual data.
Right, the impact reports will be based on, I mean, if you put the provisions you've enacted for this committee in place, the impact reports would be measuring what the actual impact of those is.
Right.
The actuarial analysis would be based on the actuarial expertise of the actuaries, estimating what the likely impact would be on premiums, which is
Kind of
what they
ironic name, an actuary,
Well,
because it's not actual.
But they are actuaries and they perform actuarial analysis.
I don't know what
They actually,
Okay, so,
the origin of that word is Miss Library.
I'll have to look it up.
okay,
Good question.
well, given the time, I mean, I'm not predisposed to be move this amendment forward, to like the amendment, but, and I think I'm open to the committee discussion at this point. We'll just take a couple minutes and then we'll see what we got.
It seems like these are big changes for us to sort of just accept from another committee without doing our own due diligence and taking testimony on it.
And we have done our due diligence.
Exactly, we've already done our due diligence on what passed out of this committee. And this is a significant change from that.
And so the one comment I would make is that I was hoping that we would get something back on the asthma paragraph from payers and providers. We haven't gotten that. If we get that, that would be helpful. And then Senator Weeks, you want to make?
I just wanted to comment that I think it's good compromise. It addresses a concern that I had throughout the testimony of the bill leading up to the vote. That I could support the amendment if we can satisfy the certain.
It will compound the fracture in terms of prior authorization with that 24 hours. I agree with Senator Hardy on that. It'll allow for payers to continue to ask for more information, and we'll be right back where we were when we tried to solve the problem.
Or it could solve the majority of the pre-authorizations that already moved through the system.
Well, they do, but remember that we had, I think it was Joy Finn who had all those prior authorizations that were redone, and then our evaluation found that the initial request was approved, 99% of the initial requests were approved. So we've got that, that's the problem we're solving, not that continuing to ask for information when it isn't necessary. And then having the reports back allow for some consideration of what's happened. And both sides will be looking at that with, eagle eye. I just know we can't lose any more primary care providers. We cannot do that. And this is losing them. I'm very much engaged in the bill as we pass it at this point.
So what are you seeking, Madam Chair, at this point?
Well,
Are we,
see, I mean, I'm looking for people's thoughts and opinions. Senator Weeks has expressed his, I've expressed mine. If anyone else wants
I
to,
agree with Senator Lee.
okay, stay right there, check that.
I stand by the work that we did previously. I think this is too big of a change to consider right now, and I think it could exacerbate the problem.
I mean, I've been in favor of the original bill, I don't know what votes we had, what the votes count would be if there were one, so I don't know if a compromise is necessary or not.
Well, it doesn't have to do, it's just here, what do we think, because we're the ones that have been working on this bill.
So
I don't
process,
see this as a compromise, I see this as a step backwards, sorry.
so,
Go ahead.
process, as I understand it, correct me if I'm wrong, because I'm still the new guy. This could be a committee, could be a committee amendment. But if not, could potentially still get introduced on the floor
Yep.
for conversation. Okay.
Yep,
Right, actually, it couldn't be a committee amendment because the committee no longer has possession of the bill. You've reported it upstairs, so it could be from whatever members, individual members wanted to
well,
sponsor.
But could pause the bill potentially. This is
Yeah.
hypothetical. Folks could testify here, and we could reject or accept. That is a potential, correct? I'm just asking because
I think
lots of subject matter.
that
issues.
could happen. Ordinarily, the process is that, based on the work that we've done, we listen to a proposal of amendment. And then based on what we have, the work we've done, we vote for it or against it. And then we take our recommendation up to the floor as part of our floor. The only question I have, continuing question I have, which is not in here and is in our proposal amendment, is on the asthma piece that now we're hearing CFR, whatever, federal. So I would welcome set some compromise language and maybe we craft that for that proposal, maybe before third reading. That one's important. So it can't be based on age, but based on, condition and ability to, take the medicine somehow. I'm looking at the people, might help us with that.
Can I ask you a question of Sarah? Is that all right?
Yeah.
Is that, I mean, after you talked to Dr. Hope, was this what she wanted to just cross this out, or did she give you a different timeline?
That's what she asked, was to remove the 5 years so that we would be able to look at someone's prior auth every year, if there's new medication stuff.
Got it, okay.
I didn't hear what you said.
I'll speak up. So Nancy Hoag, our pharmacist, thought that 5 years was too long to review medications because there's so many new generics, biosimilars, and alternative medications that come onto the market every year. She wants to be able to review someone's PA and see and approve it because they have to come in and get a new prescription.
I'm getting, so it's the prior authorization for that, the medication the patient is on is reviewed every year by the practitioner. So that already happens. We all get that, that happens. Then the 5-year approval is for what the patient is on and whether it continues to fit the patient's needs. And so looking at the 5-year prior auth, trying to figure out why that's helpful to the patient, and the practitioner can always make recommendations for a different treatment within that time frame. You know, if somebody starts not to respond adequately. So trying to sort that out to the services and others.
Yep, I understand. So one of the examples she gave me were the GLP-1 weight loss drugs. There are many, many, many of those coming onto the market. We just approved a new one for our members a couple weeks ago.
Oh, they're cheaper.
They're extremely expensive drugs.
Nice.
Many of them work very similarly, and so we would like to be able to redirect a patient to the ones that's.
And you wouldn't do that. You would do that regardless. The prior auth would be considered But you still have an opportunity through manuals and guidelines to communicate, and letters to communicate with practitioners about, this is a new one that looks better or might be used, so. Kind of, there's not a lack of communication.
Yes, the other thing is, members sometimes stay on our health insurance for 5 years or longer, but many of them don't. They move around and it's hard for us to track people. We really are looking at people in.
But then they would move and then they'd have their 90 days. And then they would be looking at the new plan. So, I mean, there's a lot in here that kind of, you're not selling it yet. When I love Nancy. She's so good.
I appreciate you considering our request is what I can say, and Nancy really encouraged me to advocate for this position.
All right, committee, so. I'm hearing that, are you not supportive of this or supportive of the amendment or?
I like the original bill.
Okay.
I still want, I wish I understood better all these cries of apocalyptic pain impacts, cost impacts. I still don't quite fully understand that, so that's problematic, but,
We'll find out. So I'm hearing 3 people who are not supportive of the proposed amendment. And it's unfortunate that that's the way it's happening. So I will, when this amendment comes up, I will say that our, the committee's line of support for the proposed amendment. And I understand that there are different opinions for different reasons, but I'm basing what I'm hearing on the testimony that we heard. So that's it.
Are you okay with the Scrivener's error correction amendment?
Oh, yes, I do have that.
Okay, it is on the committee's webpage.
It's on our website.
Yes, changing 3 to 4. In the description of the section, it's the one I confirmed with some of the advocates who've been involved to make sure it's the when the 24 or the urgent request change occurs. And it refers to, we had 2 sections of the bill that amend the same section of statute. One of them was in section 3, one of them was in section 4. They amend different subsections. And I used section 3 to describe section 4, and it should all be section 4. So this would just, from the chair, change where it says section 3 to section 4, but it seemed like more than we should just be having the secretary's office.
No, this is not just a Scrivener's error. I mean, theoretically, but.
I mean, it is, but it's, but.
You're the
People
scrivener.
But I'm the scrivener, people are paying a lot of attention to these sections, I didn't want to be.
So committee, is this something that it would be acceptable to you if we put it up on the calendar with the bill? Who would like to sign on to it, Do you want to sign to the correction?
Sure.
Huh?
Sure.
Sign off those corrections. Okay, so we'll get
Great.
it.
Thanks. This is apologies for the error. I don't know, happens, it needs to be fixed, but at
We're
least.
only drafting like 75,000 bills.
I was working on the Senator Brock amendment that made me realize the error.
Will you send it with the names of the?
Sure.
So I don't have to.
Yes.